Ladies and gentlemen, we have a very interesting topic now, and the topic is trends and new trends of challenges being made against arbitrators. Now, this is a very important topic because we see there's an increasing trend across the world for arbitrators being challenged, and quite often arbitrators are challenged for either being biased or impartial, and the reason why there are challenges being made is because it's very difficult to set aside awards under the New York Convention, and it's very hard to for a respondent or a party facing claims to get out of an arbitration it has voluntarily agreed to. So quite often it's easier to attack the arbitrator or the tribunal itself, one or more members, and to allege that the tribunal is not being impartial. But quite often the real reasons why attacks are made is for a delay purpose, so that perhaps things can happen, settlements can take place behind the scenes, etc. And quite often the speech will always start off with the parties no longer trust the integrity of the tribunal, and along that lines. Article 3.38 of the IBA Guidelines 2014 obviously comes into play. This is where it says that an arbitrator shall not be appointed for more than 3 times over the course of 3 years by counsel or a law firm. But now parties are trying to find ways of challenge. Last year, for example, there was an interesting case that was reported. There was an Icc decision where one arbitrator, Sigvat Yavin, was challenged for the fact simply because he was 76 years old, and they said he's too old, anything could happen, etc., etc. But thankfully, the Icc Court decided no, age alone cannot be a factor, and came up with a good reasoning. But in some of the arbitration centers, one of the tactics used by parties is to make such allegations, hoping that the center would not confirm the nomination of the party. Now, we have got a very good range of diverse personalities. Unfortunately, Francis Xavier can't be here today. He's become the new president of the CIARB and has to attend to other matters. But let me introduce our esteemed speakers. So we have Judge Supaji Rangroj, the presiding judge of the Udon Thani Provincial Court. She used to be the executive director of the Thai Arbitration Institute, TAI. And she holds an LLB, LLM from Chulalongkorn University, and you're barrister at law at the Thai bar. And, she will deal with dealing with challenges from the perspective of the judiciary and how they deal with such cases. Next to her, we have Liu Jing. He has a very varied career. He's now a senior consultant at Hui Tong. He used to be Deputy Secretary General of the HKIAC, and he also was at Freshfields in Hong Kong, and was at CTEC as well. So he has a lot of experience, both as appointing authority and counsel. Next to her, we have Pui Ki Ta is the counsel for the ICC Secretariat of the ICC International Court of Arbitration. Pui Ki deals with all of the cases, looks after the cases in Asia and the ICA 8. And I can personally vouch for Pui Ki that she's very sharp and extremely sharp in scrutiny. And Pui Ki is called to the French bar. Kuno Pramat is the partner at Tilliker and Gibbons. She holds LLB, LLM, and a MA and MCL. And she has a lot of experience in arbitration, local and in Singapore as well. And Kun Pramat will deal with challenges from the perspective of Thai counsel when she brings cases in the TAI, THAC, and before the Thai courts. And so she'll give a different flavor, a flavor as counsel. What we plan to do is we plan to have the first two speakers kick off, and then we'll have a Q&A session where I'll invite the audience to put questions to both of them, and then we'll continue with Priki and Kun Pramat, and then we'll have Q&As again, if that's all right. So without much ado, I invite Judge Supanji now to give a presentation.
Thank you very much, Mr. Professor Colin, and thank you to THAC and co-sponsor to invite me to be here today. I'm so glad to be here today, and thank you everyone still being here, because it is challenging for speakers in the afternoon session. Yeah, but I think many people prefer to stay here and stay longer until tomorrow, right? Yes, thank you very much. Okay, my presentation, I have my PowerPoint presentation, but there's some technical problem, so that's all right. Because I'm a judge, right? So, okay, it's coming. My presentation is the judicial perspective on challenges made against arbitrator in Thailand only. Yeah, because I am a Thai judge, right? And so at first I would like to talk about the laws or TAI rules, the institutional rules. For the THAC rule, you may be informed from Kun Pramat later on. And after that, I would like to focus on the judgment decided on challenges against arbitrator in Thailand. And if I have enough time, so I will speak about the age and health. This is the new trend for challenging the arbitrator, not in Thailand, but in the world. Okay. I think everyone here knows a lot about what is arbitration, right? And who is arbitrator? Arbitrator is one or more person who are appointed by the parties to decide their own case, right? And the decision from the arbitrator, the award, can bind the parties, right? That's okay, this is very common understanding, right? Okay, and so what kind of arbitrator the parties would like to prefer? They can prescribe the qualifications in the arbitration agreement. So maybe age, sex, nationality, right? Or some area of expertise, such as financing, engineering, or in marine insurance and so on. This qualification I can call the specific qualification. But in practice, there are general qualifications that most arbitration law and rules require the arbitrator shall be impartial and independent. Okay, maybe. What happened if the arbitrator lacks of the impartiality or independence? Okay, they may be challenged by the party, or the award rendered by them may be set aside or refused according to the law, according to the national arbitration law, okay? And as I said earlier, the arbitration law and rules in the world require arbitrator to be impartial and independent, as well. Thai Arbitration Act. We have a single arbitration act, which applies to both international and domestic arbitration and apply to both ad hoc arbitration and institutional arbitration. So it is quite easy, right, to understand. But it may be complicated when decide the case or when understand and which one is proper for international or domestic. But okay, also thus we have single arbitration act in Thailand. And a section, it's quite small, right? Quite small. Yeah, if you can't read, you can download from internet. And you can enlarge, can you? Because I cannot. In section 19 of the Arbitration Act, Thailand 2002, requires arbitrators shall be impartial and independent and possess the qualifications that prescribed in the arbitration agreement. What happened? This caused, why? I have 5 minutes left, right? This caused the arbitrator, the prospecting arbitrator, to disclose any circumstances which is likely to cause justifiable doubt as to his impartiality or independence. And so now I think I should move on this and come back to explain about the impartiality and independence. So now I would like to explain more about the process for challenging in Thailand. If the party would like to challenge the arbitrator, in Thailand, according to the law, they can do that by filing the statement stating the grounds for challenging to the arbitral tribunal. And after that, the tribunal will decide on the challenge. It means that it's decided, and the challenge arbitrator will decide the challenge also. Okay, and after that, if the challenge not successful, so the party who is unsatisfied with the result can bring the challenge to the court. You can see in the second paragraph of the section 20. What is the competent court? It depends on the kind of the cases. If just civil case, you can go to the court, adjudicate civil case like the civil court or maybe Udon Thani provincial court. But if the IP and IT case, you can go to the IP and IT court, right? We have the representative from the IP and IT court to be here today also, right? Okay, and now, I touched a little bit about the TAI rule. The TAI, I was working at the TAI, so the process for challenging the arbitrator is quite similar to the law, but it is very special things that just happen. Yeah, in section 23, because you know that, as I said earlier, if the parties challenge by filing the statement to the arbitral tribunal, and the result is not satisfied, so they can go to the court, right? But in the TAI rule, it is the newest one that if the TAI deems appropriate, they can appoint the umpire, consist of not more than 3 persons to decide the challenge, instead of going to the court directly. It is, but as far as I'm concerned, the TAI hasn't appointed the umpire like this. So maybe if maybe the TAI could consult the parties what they would like to do, what they would like to prefer, going to the court or appoint the umpire like this. Okay. I have time, right? Okay. Now, as I said, the arbitrators shall be impartial or independent, right? So, but what is impartial or independent is unclear, right? So the common understanding, impartial is unbiased, not favor one side more than other side, right? But for independent, what does it mean? Maybe free from the party or not controlled by the party. Just that, but there is no definition of two words. So we have to, and okay, in the section 20, paragraph 2, that discuss the duty of arbitrator to disclose any circumstances is likely to cause justifiable doubt as to his impartiality or independence. So what is justifiable doubt is also unclear, right? So what happens if they are unclear? So we have to study from the judgment of the Supreme Court and the Supreme Administrative Court to look for the approach of the court in deciding the challenge, right? So as far as I'm concerned, there are not so many cases about the challenging of arbitration in Thailand. But you can see, sorry. Okay, there's several judgments that I would like to talk about that, but not in the detail, just the overview of this. Okay, the first one, judgment number 3452 in the last year, with the newest one. The arbitrator in this case, the chair arbitrator in this case was challenged because he was the legal representative of one of the insurance company. No, it is not the party in the arbitration case, but for arbitration case, the defendant is the other company. For the previous case, he's the legal representative of the defendant and argued that the defendant should not pay for the compensation because the damage arises from the riot, which is the exemption for compensation. So for this case, this person is appointed to be the chair arbitrator. So the claimant challenged this person by claiming that it's quite common that he has the same opinion on this issue. And and after that, this challenge is go to the court, the Supreme Court, and the Supreme Court held that it's quite common that in the same situation, so this person has to have the same opinion on the riot, on the situation that maybe the insurance company does not pay for the compensation like this. Okay. Okay, I have only another 1 minute. So I would like to talk about the third judgment. This is not direct challenging case, but the party would like to set aside the award and claim that the arbitrator hold the shares in the defendant's company. But the arbitrator argued that he is just the nominee not the real shareholder, but the court designed that he has to disclose this circumstance to the party to object, but they failed to disclose. So it's deemed that he's impartial. Okay? Okay. Yeah. Maybe the second round. Okay, thank you very much.
Thank you very much, Judge Sapaji. So, Liu Jing, are you ready?
Yeah, I'm supposed to give a brief report on the challenge of arbitrators in China, which is actually not an exciting area. So I just remind you, it's boring. I just start from the basic structure. At the legislation level, it's very simple in China. It's just a conflict of interest with respect to the parties or the counsels that may affect the impartial trial of the case. No further concept of apparent bias or actual bias. No further elaborated rules or tests like real possibility test. No, and no disclosure requirements under the Chinese arbitration law. That's a basic legal structure. So it's basically left to the arbitral institutions to deal with the issue. You know, there are 200 arbitral institutions in China. Most of them have similar rules. Under those rules, the concept of justifiable doubts is established. Also, the disclosure requirement is also established under those rules, which are very similar, as I said. But the tests are not very articulate under those rules. What's the test for disclosure? What's the test for justifiable doubts? But in practice, it doesn't seem to be a problem. So probably generally people would think the normal way, the logical way is the disclosure has a lower test. The circumstances that may give rise to a justifiable doubt as to the impartiality and independence of the arbitrator may arise. Then you have to disclose. And when the circumstances in which the justifiable doubt as to the impartiality exist, then you can successfully challenge the arbitrator. So that's, even it's not very clear on the paper, in practice, that's the normal way people think or approach this issue. So it's not a big issue there. There's no big issue there. And then in addition to the rules of the institutions, there are internal guidelines in the form of ethics codes, conduct codes, in the traditional way. It's only for the arbitrator's reference, but may be used or taken into account by the court in the setting aside procedures. So that's the traditional way. The latest development is the BIAC. Am I allowed to say that, Professor Dr. Chen? It's a new latest development of BAC or BIAC. It's still internal guidance, but it's very comprehensive, traffic light style, very similar to IBA guidelines. It recently was announced internally by BIAC. As you know, BIAC is the pioneers in arbitration in China in many fields. That's one of the pioneering activities. It's very comprehensive because I'm an arbitrator of BIAC. I studied it, so it's a very comprehensive, very instructing. So that's the internal guidelines. In addition to that, some institutions will refer to the IBA guidelines as international best practice. For example, in Shenzhen Court of International Arbitration, on a few occasions I was involved in the practice of that institution. They always go to the IBA to check the conflict of interest. So it's a kind of internal but informal reference for that institution. So that's the legislation, rules, and guidance level. That's the basic picture of the challenge of arbitrator in China. But in practice, I would say it's a not big issue in China because it's normally dealt with, I guess, like in many other places, informally and more important, practically. That means by the withdrawal of the arbitrator, that who may potentially be challenged. it happened more often, I think, in domestic cases. In that context, the tribunal know each other well, know the parties well. The institution know the arbitrators well. The background is shared by the small community of the arbitration community. So by communication, it's easier for the arbitrator who might be challenged by the parties say, okay, I don't want to get into trouble, I'm going to resign or withdraw from my appointment. That's informal, but I think it's also very practical. I think the communication between the arbitrator, between the institutions, much easier than in international arbitration. I think it's not necessarily a bad thing. It's probably you say, okay, you lose the chance to establish the precedent, to develop the law. It's okay, let's understand. But on the other hand, practically, for the smooth running of the case, probably withdrawal in some cases is an easy and practical way to deal with the problem. That's in practice. The institutions, I think like all the institutions, are rather reluctant to make a formal challenge decision based on the party's allegation. It's a hard decision to make because it's very fact-specific, or depends upon your feel of the circumstances, whether in your mind it will raise justifiable doubts. So understandably, the institutions are very reluctant to make the decision. And if they make the decision of the institution will be final say in China arbitration practice. The parties cannot go to the court unless you go to the court to ask the court to set aside the award based on the impartiality or independence of the arbitrator after of course after the award was issued. So that's the basic practice. But in China, the difference from other places, I guess, I don't know other places very well, but in my general impression is in China the pool of arbitrators is very diversified because challenge is all about arbitrator. If you have diversified pool of arbitrators, different backgrounds of arbitrators probably may call into questions different types of relationship. For example, in China, law professor is often appointed as arbitrator. Then the professor and the student relationship is often become an issue people to discuss on. That's very kind of a special in the China context. So also we have there are government officials, the in-house counsels. So if those people are acting as arbitrator, definitely the relationship surrounding them will be different. Then you would have different consideration for that type of relationship. So that's different. It's a good thing in China you have more diversified pool, but not 90% lawyers. That's a good thing. But on the other hand, you have more broader challenge in terms of different types of relationship those arbitrators may involved or engaged in these circumstances. That's the thing. Now, the very end of my presentation, I need to go to some very specific points. For example, repeat appointments is a kind of a popular topics in international arbitration. You all know the IBA rules. If the parties appoint, the same party or law firm appoint the arbitrators two or more times within past 3 years could be a repeat appointment. But in one of the guidelines of the domestic arbitration institution is 5 times within 3 years. It's different from IBA. That's the only thing I see very specific time, the years showed up in the guidelines other than IBA. I think it must be a result of the careful study of local needs or the needs of the local market. Give more weight to the arbitrator's expertise and to the party's right to appoint an arbitrator with the expertise they wanted. That's one thing. But on the other hand, doesn't seem to be an industry exception like IBA rules for sports, for maritime insurance. But again, it could be the other side because they have done the research, probably they know the need in the local market. So that's one thing. But as I said before, it's very fact-specific issue, challenge of arbitrator, as we can see in the IBA rules, preface to the orange, red, or green list. The very important one sentence is, in all cases, the general standard should control the outcome. So it's good, we have many rules, many guidelines, you list all those situations, it's helpful. But by the end of the day, in each individual case, I think still the justifiable doubts should control the outcome. So whether it will be justifiable doubts or not in a specific case, probably you have to make your own decision based on the specific facts of the case. So the other guidelines or the case, it may be helpful, it may be not. So that's why it's a difficult issue. If it can be dealt with practically and informally, it's not necessarily a bad thing. Thank you.
Thank you, Liu Jing. Before I throw it open to the floor to ask questions, perhaps I'll ask a question each to each one of you. For yourself, Liu Jing, could you explain about the difference in the tests between the IBA 3.3.8, where an arbitrator can have only 3 appointments in 3 years, and in China, where you can have 5 appointments but in 3 months, but not more than that. How do, so far, how do the courts deal with the matter of bias or perceived bias when the time frame is quite short, and within 3 months you would not have an award yet generally? So how do the courts go about dealing with the challenges?
Did I say 3 months or 3 years? I think it's 3 years.
Oh, 3 years.
Yeah, 5 times within 3 years. So there haven't been any cases in this regard because it is quite new, these guidelines. We haven't seen any cases. But that impressed me because you have the specific, the figures in that, the different from the IBA, the guideline. That's why it caught my attention to. That's the problem. But as I said, still, actually, I have a question for this type of thing. Whether in the guidelines, as the IBA does in their guidelines, say the general standard should control the outcome in all cases. So even apparently the requirements or conditions are met, will there still be any circumstances in this case that we can say no, even apparently the conditions are met, but still we don't believe there is a justifiable doubts under these circumstances? I think the court or the institution may still have some discretion or room other than the apparent or superficial stipulation in the rules or guidelines.
Perhaps on this note, I can invite the audience to follow up with any questions. Victor Leginsky from Dubai.
Thank you very much. Thank you, Dr. Cullen. This is a great session. I really appreciate your work in organizing this and organizing the conference. Yes, Victor Leginsky from Dubai, Chartered Arbitrator. There's a type of challenge to arbitrators which sort of, to me, seems to blend into procedural defaults or defects. That is, if an arbitrator doesn't seem to be allowing a party an opportunity to present its case properly, or in some cases refuses an adjournment or refuses to grant a hearing for an interim small matter, sometimes those give rise to challenges, which seem to me to be odd in the sense that you can set aside an award for procedural irregularities, and if an arbitrator has not given an opportunity to present the case to the parties, then again, that gives rise to a challenge or a resistance to enforcement. But where do you think you should draw the line in terms of that becoming a challenge or a challengeable event in your region? Because I know under certain rules, the Icc rules, for example, if you refuse to grant a hearing for an interim matter, that can give rise to a challenge and has done so. In this region, does that intrude very much, or does that become an issue here? Thank you.
Can I invite both of you to give your views, please?
There are not so many cases in China, the court practice in China, but a long time ago, probably 13 or 15 years ago, there was a case because the presiding arbitrator made some inappropriate comments on one of the parties who is from Taiwan or a Taiwan company. That the parties asked the chairman to withdraw. He didn't. He refused. And then the court, in the setting aside procedure, say, okay, you made the bad comments about the particular type of parties. You violate the conduct code of the institution. So the word was set aside. That's only one case I know in China that involved the conduct or acts of the arbitrator during arbitration proceedings. Most cases are concerning about the relationship between the arbitrator and the parties. So it's very, very few cases, I would say.
Any other questions from the floor? Yes, Hyun. KCAB.
Thank you for just having this wonderful session together with you. I'm Hee-Won Kwon from Korean Commercial Arbitration Board International. So my question goes to Madam Judge. Actually, just general audience asked me how to draft arbitration clause. I really stress out to not put just too complicated element into the contract or arbitration agreement, especially when you just describe the qualification of an arbitrator, you should be just aware of that importance of it. If someone just wanted to just expert, actually just arbitrator should be expert in that dispute resolution matter. But however, could you evaluate his expert or not? So in your slide, probably in the second page, you will describe that maybe just there is a ground for challenges that impartiality, and secondly is a lack of qualification. So from your own experience, could you share just any experience there was a challenge to a Thai court and the lack of qualification, and could you just come out just a result, how you come out? Thank you.
Thank you very much for your question. So with the second one, right, the part is the qualification that's prescribed in the arbitration agreement. So as I said, not so many cases on the challenge or against arbitrator. And as far as I'm concerned, there is no challenge on the qualification that's prescribed in the arbitration agreement. But in practice, if the arbitrator are not in the qualification that prescribed in the agreement, so maybe the parties knows and aware about that and said in the first meeting, they are not going to object this qualification and waive for raise this challenge in the court or the tribunal. That is in practice, yes. But if or in contrast, maybe if the party is aware that he knows has no qualification like identified in the agreement, so he withdraw from his office already. So that is not a technical problem. Thank you very much.
Thank you, Supaji. Shall we now move on? Puiki, do you want to give your presentation?
Yes, thank you. I think we have issues with my slides. Do you need me to send them again? Or we just proceed without the slides, please, without. Yes, thank you. So it's a great pleasure to be here today to share with you the ICC International Court of Arbitration's experience concerning challenges made against arbitrators under the ICC rules, including recent developments in the court's practice. So when referring to the ICC, I will be referring to the International Chamber of Commerce, just to clarify. Since its creation in 1923, the ICC International Court of Arbitration has administered more than 25,000 arbitrations. And one of the key functions of the ICC Court is to is to ensure that when applying its rules, is to vet arbitrators for independence and impartiality. And Article 11 provides that every arbitrator must remain impartial and independent of the parties involved in the arbitration. Article 22(4) of the rules also provides that in all cases, the arbitral tribunal shall act fairly and impartially and ensure that each party has a reasonable opportunity to present its case. The Icc Court's role is to ensure that this fundamental principle is respected and upheld at 3 different stages: when confirming or appointing arbitrators, when examining challenges against arbitrators, and when replacing arbitrators on the court's own initiative. And my presentation today will only be focusing on formal challenges brought against arbitrators under Article 14 of the Icc rules. Now, I'm going to say a few words about the challenges process before the Icc Court. Challenges are examined and decided by the Icc Court once a month in a plenary session where all the court members are invited to join. The Icc Court first decides on the admissibility and at the same time, if necessary, on the merits of the challenge. After the circuit has invited comments from parties, the challenging arbitrator, and the other members of the tribunal. The Icc Court may also provide reasons for its decisions, and I will come back to this later. Now, a few words on the admissibility of a challenge. Pursuant to the rules, for a challenge to be admissible, it must be submitted by a party within 30 days from the date when the party making the challenge was informed of the facts and circumstances on which the challenge is based. And very often it is clear that challenges are timely and admissible, so the only live issues go to the merits. Article 14(1) allows for a challenge against an arbitrator based on an alleged lack of impartiality or independence or otherwise. A challenge may be raised under either the element of independence or impartiality, or the other element, catch-all element, or otherwise. And whilst the rules do not go further to describe what that means, the Icc note to parties and arbitral tribunals on the conduct of arbitration under the Icc rules provides additional flavor to that provision and to the standard applicable to disqualification. So in the Icc note, paragraph 21, it is required, the proposed arbitrator is required to bear in mind any circumstance that might be of such a nature as to call into question his or her independence in the eyes of any of the parties or give rise to reasonable doubts as to his or her impartiality. The alleged concern needs to be seen through the eyes of a reasonable person enjoying all of the relevant background facts. And the note at paragraph 28 also states that in addressing possible objections to confirmation or challenges, the Icc Court will consider the activities of the arbitrator's law firm and the relationship of the law firm with the arbitrator in each individual case. That is an objective test applied by the court. And challenges filed in Icc arbitrations are handled in accordance with Icc rules and in light of previous Icc decisions that the court has taken. However, the Icc Court is not bound by any of its previous decisions, but examines a challenge on a case-by-case basis and considering all of the facts and circumstances of the case and considering each of the parties' arguments and the challenge arbitrator's arguments. Although not directly applicable or binding, the IBA guidelines on conflicts of interest in international arbitration may also be referred to, but they are not binding on the court. The Icc Court's practice of assessing challenges on a case-by-case basis gives the court flexibility to adapt to any new circumstances. And at the same time, it is important to create predictability in the treatment of challenges and to discourage the use of challenges as a delaying tactic. This is the reason why the court has implemented 2 new related changes to its practice concerning challenges in order to make its decisions more transparent. And the first one concerns challenges rejected on the grounds of inadmissibility, and the second one is the communication of reasons of the court's decisions on challenges. In the past, the court informed the parties and the arbitrators of the rejection of a challenge without specifying the reasons or indicating whether it was due to inadmissibility or lack of merit. The court also did not give any reasons to its decisions on challenges. So this has been changed in 2017 to allow the court to communicate reasons on decisions upon request of any of the parties, and provided that such request is made before the matter is submitted to the Icc Court. And to date, the court has communicated reasons relating to challenges in 15 cases, 3 in 2017 and 8 in 2018. A few statistics now. Despite the increase in the number of challenges, the statistics of the Icc in the past 5 years show that the percentage of challenge arbitrators has remained quite stable. 60 challenges were filed in 2014, 50 in 2016, 48 in 2017, and 45 in 2018. The rate of accepted challenges is very low when compared to the challenges filed, but the success rate of challenges appears to have been increasing. Back in 10 years ago, only 1 or 2 challenges were accepted by the court. And whereas this number has been higher now, reaching 6 in 2017 and 7 in 2018. I'm going to say a few words about accepted challenges, when challenges are accepted by the court and when they are rejected by the court. As you may know, parties, as Victor just mentioned, parties to Icc arbitrations challenge arbitrators on a variety of for a variety of reasons. Challenges are based on an accumulation of several grounds. So the court will have to examine each of these grounds to see whether they give rise to any justifiable doubts which merit the removal of the arbitrator. And successful challenges are often based on a number of separate but related grounds that are beyond mere procedural misconduct. Yuting just mentioned repeat appointments. We've seen this in Icc cases as well. I'm not going to expand on this. Other successful challenges were based on grounds such as delay, inefficient and bad management of the proceedings, disruptive and inappropriate behavior of the arbitrator, or inappropriate language used by the arbitrators commenting on the challenge. Let me give you 3 cases, recent cases where the court has accepted the challenge. The first one, the court decided to accept the challenge against the president of the arbitral tribunal on the ground that she was no longer communicating with the parties for almost 2 months and not fulfilling her functions as president. That challenge was accepted by the court. In the second case, the court accepted a challenge against a co-arbitrator for improper behavior, which consisted in disclosing confidential information resulting from the arbitrator's deliberations, refusal to participate in the proceedings, improper behavior towards fellow arbitrators, which consisted in questioning the independence of the president and insisting on the removal of the president. In the third case, the court accepted the challenge against a co-arbitrator on the ground that the response to the challenge from the challenge arbitrator was illustrative of bias and inappropriate behavior. Challenges solely based on procedural decisions rarely succeed. However, in taking decisions on those grounds, the Icc Court will verify that the parties were treated equally and were given the opportunity to present their case, and that the tribunal's decisions were balanced and reasoned. The Icc Court is generally reluctant to accept challenges based on the arbitral arbitrators' procedural decisions, such as denying a party's request for a hearing, postponing the dates of the hearings, or suspending the arbitral proceedings. And one of the most frequent grounds we have recently seen is the lack of reasoning or insufficient reasoning in the arbitrators' decisions contained in various procedural orders. Maybe just a few words on other unsuccessful challenges based on qualifications of an arbitrator, on the age, as mentioned by Colin, and also on the nationality of an arbitrator. We've seen more and more challenges based on those grounds. And I think we might see more challenges. It's true that we have not seen many challenges based on the age, but we might see more in the years to come, because, as you know, one of the ICC priorities is gender and age generational diversity in the appointments of arbitrators, and that might potentially give rise to certain challenges due to differences in working styles, interest, and approaches to issues. Thank you.
Thank you, Puiki. Kun Nopramat.
Okay. Good afternoon, everyone. After we already listened to our judge perspective and the arbitration institution already, so I think that right now, come to my presentation is actually focused on the counsel perspective. I act as the both claimant and respondent counsels. So this topic is kind of interesting to me. Actually, why we challenge the arbitrator, right? We want to protect. First is there are two aspects. The first aspect that we want to protect the due process. That we want the arbitrator to be impartial and to be independent. These two words is very vague, right? So I think that the other side of the aspect for the challenging the arbitrator is actually tactic to disrupt proceeding. No one can say that, okay, we have the good intention to challenge. Yeah, it can be good intention to challenge arbitrator and to bad challenge to the arbitrator. As the counsel, when we appoint when we nominate the arbitrator, actually it's not the appointing. Both parties have to agree to appoint the arbitrator together. Even though the claimant nominate one, that arbitrator cannot be appointed if the respondent counsel challenge. That's right. So the arbitrator become the arbitrator for both parties, not to become the arbitrator of any party. The arbitrator cannot make the decision in favor of the party who nominate them. I'm really glad to hear the statistics regarding to the challenge from our friend here, ICC, because I'm going to share with you the another statistic from the London Court International Arbitration. Also interesting that this is the statistic from 2010 until 2017. So from this statistic, I show this because from Thai Arbitration Center, TAI and THAC, I try to obtain the information how many challenges for the arbitrator. They said that they haven't kept the statistic, but yes, there are some challenges that I will share later. But you see, from the LCIA statistic, the success, actually only 2% of the cases that had been challenged arbitrator, 2%. But comparing for the successful challenge, it means that the arbitration institution remove the arbitrator is 0.4%. It's 1/5 for the successful rate. 2% for the challenge. What does this mean? Actually, this may not comply to Thai context, but I consider at the international context that the council very careful in order to make the challenge against arbitrator. Why? Firstly, you have to be very sure that if you challenge and the ground, you have to establish the legit ground in order to remove this arbitrator. Otherwise, he will come back, right? If he come back, what happened? You make him unhappy. That could cause some problem to your case as well. That's why I think that it's important to see that 2% of the challenge of the arbitrator was low, but the successful rate quite high, right? I share with you another thing that for why I share for the London Court International Arbitration Rule. Actually, we have very short time. Have to speed up. Okay. The London Arbitration Court and also THAC rule, you can see that the term for the court of challenge quite not clear. What happened in Thailand is that when we try to challenge the court right now, I think that one of our friends already raised the question. The council tried to see how the arbitrator conduct the proceeding. If the arbitrator conduct the proceeding that actually seem to be unreasonable or not according to the rules of law, that is something that the council look at for the opportunity to challenge. In my view, when we challenge, sometimes we not challenge because that we believe that the tribunal going to remove the arbitrator, but we challenge in order to remind the arbitrator that he or she have to make the decision or conduct the case properly. I have experienced one international arbitration case in the neighboring country. That for this case, it's quite interesting that the arbitration case already closed. The final witness already testified, and the arbitrator declared to close the proceeding. The arbitrator set the date for grant the award already. What happened? The respondent counsel made the submission that he want the arbitrator to have another witness to testify. He made this 2 times, and the arbitrator dismissed both. And then what happened? Yeah, just like our friend asked, the respondent counsel submit the challenge against arbitrator. And what the challenge is regarding to the improper decision and also the laziness of arbitrator. The respondent counsel submit all the time that the arbitrator come to the room, how many minutes left, blah blah blah. This kind of thing that you can see that okay, 2 submission as our ICC friend here told us that is the repeating submission. And the content of the submission is something that seems to be why the arbitrator come late 5 minutes, 10 minutes is something not serious in the international practice, right? You can be like 30 minutes less, it's okay if you can explain why. But in this case, yeah, the institution said that, okay, for this case, it seemed to be personal interest made by the counsel to challenge the arbitrator in this case. So I want to point out that as the counsel, yes, we look to challenge the arbitrator in order to protect the due process. But on the other hand, sometimes clients also have some purpose. You can say that, yeah, delay the case. In order to delay the case, to challenge the arbitrator may be not a good solution in my experience, because it can come back like boomerang. Okay? So that is my experience as a challenging arbitrator.
Thank you very much. Bang on time. Right. Can I invite more questions from the floor? David Bateson.
Thank you for an interesting session. Just one flippant comment, then some questions. Saying an arbitrator is too young or too old is a bit ridiculous. I mean, what's next? Too good looking, too ugly? Puts the council off? Where do we go with this, seriously? Now, on a more serious note, I want to ask the panelists your views on the following challenges. One is that the council, the proposed arbitrator is in the same chambers as the counsel in the case. Second, the proposed arbitrator worked 10 years ago in one of the law firms. And the third is the proposed arbitrator has written many articles and books with firm views on a particular issue in the case, issue estoppel. I'm just interested in your views on that as panelists. They're quite controversial.
Who would like to take the first point?
Okay, I think that for the arbitrator, yes, arbitrator come from practitioner in law firm, come from the law professor, just like that. And they always have the view or opinion on the legal perspective. They make the interpretation of the law. There was one case is in Thai court that the lawyer. This lawyer is actually the case that the judge already informed you. He made the opinion on the case. He submitted the answer in the insurance claim case, and he defended the case for his client. His client in this insurance case is not related to any arbitration case that he been challenging. And this lawyer later been appointed as the arbitrator. You see, from this point, you think that this arbitrator who was the defendant lawyer in the insurance claim case, should he review this information before he was appointed as the arbitrator or not? Because actually, it's not related to both parties, not related to the claimant and the respondent. However, later the respondent said that because he failed to disclose about his legal opinion view, therefore, this caused justifiable doubt. Actually, I disagree with the court judgment with my respect. But I think that because every lawyer we have all the different view on the legal aspect, if we not advise the party, we not receive money from the party in the arbitration case, that's fine. And in this case, Thai court believes that this arbitrator should be removed, and he should, because he failed to disclose about the case that he defend in the Thai court. Okay.
Pui Ki, do you want to deal with the second point?
Yeah, just one comment regarding your remark on the age of the arbitrator. We do have cases where a party filed a challenge against the president who was younger than his co-arbitrators, and that, of course, a challenge was filed. Otherwise, so I think for those three scenarios that you mentioned, we've seen this in ICC arbitrations quite often, but it's very difficult for me to tell you whether they were accepted or rejected, because it's very, as I said, the assessment is on a case-by-case basis and looking at all the parties' arguments, comments on the challenge, on a specific challenge, and looking at all the facts and circumstances of the case. So, so usually a challenge will be accepted by the case, by the court, on those grounds if they are coupled with other factors. And the court will look at whether there is like a material connection between the arbitrators, there is a close connection, personal or professional, whether there is any financial link. And if those elements are present in the case, then the court will be satisfied that they are justifiable doubts, and then will decide to remove the arbitrator.
We got two more. Well, I think I could probably deal with the other point on members from the same barristers' chambers. And I think it all comes down to the first case that sort of like opened the floodgates was Hrvatska versus Republic of Slovenia in 2006, where the presiding arbitrator and was there first, and then lead counsel came in later. They were actually from my former chambers, and then there was a challenge by one party to say, look, you can't have two members of the same chambers. One is presiding arbitrator and one's lead counsel. Well, the solution there was last in, first out. So the lead counsel was asked to go because the presiding arbitrator wasn't going to leave because he was appointed first. But after the 2014 IBA guidelines on conflicts of interest, the second edition came out, and there's a little section on barristers' chambers. It did cause a little bit of internal thinking, and there were more challenges being raised by people who just said, look, it can't be. Everyone shares the same premises, etc. Whatever Chinese walls you have wouldn't really work. So the English bar came out with practice guidelines to warn barristers' chambers on how to deal with this. But obviously the writing's on the wall, and that's why you see a lot of well-known arbitrators leave large chambers to go to smaller chambers or set up on them by themselves. But the challenges are more novel now, I suppose. They even challenge if arbitrators sit together in different cases, but that's not part of any guidelines. But nowadays you see all sorts of challenges, including allegations that arbitrators know each other better because they've sat with each other. But I don't think the ICC or LCIA or any institution has yet upheld such a challenge. But I think we can see more similar challenges coming in. What about in China?
I think it also depends how the chambers behave themselves, because I've been from China, Beijing, Shanghai. Frequently, we receive delegation from particular chamber to do marketing in China. So if you do those things more, people more have the more perception you're the same firm. You share the marketing. I don't know. It's probably one of the factors to consider. The operation in different ways, probably nowadays.
Any other questions? Ronald Sum first, then Philip. Yeah.
Hi. I have three questions. The first question is to Pui Ki. If I'm not mistaken, you mentioned that recently there is an increase in the challenge to the impartiality of the arbitrators. Is there any reason why there is such increase, or is it just a strategic move that the lawyers decide to go for this type of challenge nowadays? The second question is more towards the tribunal, to the panel. Is there any common grounds of challenge by the lawyers representing the parties? And of course, the third question is, in particular in Thailand, are there any common grounds that you see more often in challenging the arbitrators' impartiality, etc.? Thank you.
Thank you, Ronald. About the statistics on challenges, I think it's quite stable. The number is quite stable. For the last 5 years, there's no increase, but I think there's an increase in the successful challenges compared to 10 years ago. 10 years ago, in 2006, between 2006 and 2008, only 1 or 2 challenges were accepted by the court, whereas now we've seen that number increased to 6 and 7 the past 2 years. But the number of challenges is quite stable, yeah.
Any reason why?
I think because there is a, more arbitrations, but the pool of arbitrators has not increased in parallel to the increase of the number of arbitrations at the ICC.
Philip Young's got a question.
Yes, I have a question with regard to some of the subject that has been talked about, like repeated appointment, disclosure. I remember before the Christmas, we have a Supreme Court case in England, the Halliburton. I know the arbitral institution, they all intervened and gave completely different views, LMAA, ICC, Charter Institute, LCIA, and so forth. I didn't follow what has happened. I thought the Supreme Court should have made the decision by now. Anybody can help from the floor, or perhaps the panel will be most grateful.
Maybe we'll see lots of different judgments as well. Anyone want to comment on that? No. So we can have a drink later and discuss that. Any other questions? Abe Shinichiro.
Thank you. I'm Shinabe from Japan. I have a little bit different kind of aspect. I'm initiated from the Judge Langrod's Supreme Court cases, just one case, because we, Japan, also suffer the Supreme Court case set-aside challenge. And the District Court, Appellate Court, Supreme Court, it took us over 7 years. And still pending, meaning from Supreme Court to go down to Appellate Court right now. So there is a criticism. How long would it be after finishing getting arbitral award? So my question to the judge is, how long would it take from the challenge to the Supreme Court decision? And is there any criticism about the timeline? And the second is ICC quickie. How about the average or normal time to resolve the challenge? And from Thailand, Nopama, sorry, I'm not good at pronunciation, but how about Thailand? You also mentioned about the challenge. Timeline, and is there any criticism about the very long time to resolve the case? Challenge, I mean. Thank you.
Okay, thank you very much for your question. This is very challenging question because I would like to know, like you, how long? It depends on the case. Is it determined on the case-by-case basis? And then I also said earlier, right? There is several competent court in Thailand, so it depends what is the court to decide. So. I could say that some case, it takes about 6 months or 1 year. So it's not too long. Yeah, and the arbitral proceeding can keep going or suspended for waiting for the judgment of the court, right? But in some cases, it's very, very big, so it takes more than 3 years. Yeah, and in Thailand, arbitration case is quite special because if the judgment of the court of the first instance rendered, so the party can appeal to the Dika court or Supreme Court directly, not through the appeal court. Yes. Thank you very much.
Regarding the timing in an ICC challenge, I would say it's between 3 weeks to 6 weeks. It depends on when you file your challenge. As I've mentioned in my presentation, the court decides on challenges once a month at the plenary session. And the plenary session of the court takes place at the end of the month, the last week of each month. So if you file your challenge the first week of the month, the Secretariat will then grant the parties and all concerned, including the challenge arbitrator, an opportunity to comment on the challenge first. Usually we give them 7 or to 15 days to comment, and then maybe there's another round of comments. And then we need to prepare the documents, a report, and a recommendation to the Icc Court. So we need to prepare that 15, maybe 7, 10 days before the court session. So I think usually the timing is 3 weeks if it's filed, on time for us to go to court and prepare everything, and if we have gathered all the comments, but it can take up to 6 weeks.
Okay. Hello. 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 Okay. The timeline to set aside the arbitral award in Thai court. But actually, as the judge said, is take from the first instance court to the Supreme Court. Even though 2 levels of the courts, in my experience, to handle this kind of case, in the past 10 years, yes, it could be 7 years, like in Japan. But right now, recent year, I think that the court moved quite quick, because after we filed the petition to enforce the foreign award, 3 months later, we require as the plaintiff to enforce the award, we require to bring in the evidence and the witness to testify. That can speed up the case, and recently, I think it's take 8 to 6 months in order to obtain the first instance court judgment in Thailand for the IPIT court that dealing directly with the arbitration case. And for the Supreme Court right now, they also move very quickly. We obtain 1 and 1.5 years in order to obtain the final judgment. So totally it could not be more than 3 years in Thailand in order to enforce the foreign award or to set aside the award. Okay. And also another thing to challenge the arbitrator, actually TAI and THAC, they set very limit time, no more than 30 days in order to consider whether to remove or to dismiss the submission regarding to the challenging of the award. And usually in my I already ran out of time as well. Okay, in my experience that, yes, we challenge in the arbitration institution. It's like 1 month, and we got the judgment from the tribunal whether or not to remove that challenged arbitrator or not. However, the wasting time that the unsatisfied party, they file the case to the court always. They always file the order of the tribunal to the court. That's why the case could be dragging longer, because it's not finished at the institution, but it will always it usually go to the court. And when you go to the court, you have two court. Yeah.
we've got 4 minutes left. Maybe I'll throw a question open. We've got so many experienced practitioners and heads of arbitration centers here. Do you find that more challenges are made in cases which, following institution rules, because they tribunals are paid on an ad valorem basis, on a percentage basis, and you find a trend where large law firms make multiple applications. They make applications after applications because they got large teams, and they're hoping to tire down the tribunal, and then bring an application to challenge, to say that the tribunal is not performing or it's not coming out fast enough with decisions. So I think the question is, first of all, do you find that sort of trend coming into play? And secondly, do you find that it works more, or you see it more in institutional cases where tribunals are paid ad hoc? Any views, please? Perhaps from my fellow panelists as well. Yep.
Thank you very much. Yoshi Hayakawa from Japan. I'm from a newly established institute in Japan, which is called the Japan International Dispute Resolution Center. And so first of all, already Mr. Abe from Japan mentioned about our Supreme Court case. And that Supreme Court case, he said that we took so long time from the beginning of the district court to pending, and finally the Supreme Court, and that case is going back to the High Court. So but the reason is, first of all, we have not yet adopted the first, the one-tier court proceedings for the setting aside arbitral award or some other, the judicial issues for the arbitral awards. And like Switzerland or some other jurisdictions have already adopted. And additionally, this case is a very complicated case, it's a tough case, because one of the problems of this case is the arbitrator forget to disclose the relationship with the party and their law firm's colleague. But that law firm is a global law firm. So unfortunately, it is sometimes very difficult to find the relationship with their colleague in San Francisco from the Singapore office. So this kind of the global activity of the global law firm will perhaps include the risk of such kinds of the challenges. And in that case, additionally, the colleague newly joined the law firm in the different office in the different jurisdiction during the arbitration proceedings pending. So that is a very tough case. That is the reason why we had to examine carefully this case anyway. So we Japan anyway, realized the problem of what Mr. Abe mentioned. So we are now in the process of reforming our system itself, and our institute is established for this purpose. But anyway, so this issue will be explained tomorrow. But thank you very much, and I'd like to emphasize the risk is increasing now because of such kind of the activity of the global activity of the law firms. Thank you.
Thank you, Yoshi. We've run out of time, so falls on me to draw this session to a close. May I ask all of you to join me in giving our speakers a round of applause, please.
Thank you so much to the moderators and the panelists as well for a very interesting topic.